Hey friends, Nate with Keyrenter Property Management here, and today I want to give you an update on two of the big bills that were pushed forward during this legislative session, one that's passed and one that has not, and I'll share with you some thoughts on those, as well as some lease updates or recommendations based on the current and past legislative sessions and other things that have just been going on in our world of property management and owning rental properties. And so, first of all, if you like this video, if you're getting this for the first time, you can click the subscribe link that's either below, above, or on the video, and you can get these emails with relevant tips and information about our industry, information about real estate investing or being a landlord or property management, those sort of things that could help you in your real estate business or in your landlording business. First thing I want to share with you is HB 268. Okay, so this was a bill that was put forward to amend the Fit Premises Act. Fit Premises Act is essentially, here in Utah, the act that requires landlords to keep properties at a certain standard and to respond in a certain amount of time when there's issues, habitability issues, but also it requires so much notice to the resident for entering their unit. Currently, it's 24 hours notice or whatever is agreed upon in the lease agreement. So this bill would amend that by stating it's just simply 24 hours notice, and you cannot modify it based on the contract. And there would be three exceptions to the 24 hours notice. One would be court order, emergencies, or abandonment. But we know as landlords that there's so many other reasons why we might need to go into the unit without giving a full 24 hours notice. What about suspicion of illegal activity? What about potential abandonment where we don't know that it's abandoned, but we have to verify? There was so much gray area about this that luckily this bill was actually not passed. So this is one we don't have to worry about this year. It may come up again in the future. And again, the UAA, our Government Affairs Committee, and many others will continue to combat this specific bill. Bill number 2 is HB 68. And this is essentially requiring renter expenses to be disclosed fully on the rental ads. Before someone were to apply for a property, you would need to disclose all the potential charges. So what the late fees would be, utility fees, those sort of things being disclosed. And it gives the tenant the option to get their application fees back, their deposit back with no consequence in the event that they go to sign the lease and the charges are different than what you advertised. So this bill did pass. And so it will be signed into law. There's going to be some best practices that will be shared with you, and we'll be able to get some information out on how we can actually respond to this, making sure that we're doing things properly. Now, this is a bill that we actually supported with the UAA and those that have been working towards some middle grounds with different people. That's the thing about this business is we can't just fight everything. We have to have some compromises, gives and takes, as well as seeing what is in the best interest of our residents that we care about. It's not always about the landlord and protecting landlord's rights, because there are some bills that can benefit both sides. And this is one of those for us. We've always taken it upon ourselves at Keyrenter to advertise what the tenant's going to get, right? Have you ever bought a car where you are sold something completely different than what you go to sign for when you see all the fees? And the numbers, just the end bottom line numbers, are so much different than what you were expecting. It can be frustrating. And for many residents that have struggled with that same thing, it can be frustrating for them to see a rent price advertised at $1,300 a month. And then it turns out their monthly expenses are closer to $1,800 a month. So we can do a better job of advertising, disclosing. And so this bill will require us to do that. Okay, I'm going to move on from the bills. But again, HB 268 did not pass. HB 68, feel free to Google those numbers, put in HB 268 Utah legislative session or something, and you'll see the bill and you can read it in more detail. The second thing, though, is on the lease agreement and some of the modifications that are being recommended. Many of you know that we use the services of Kirk Collimore, and he's our landlord attorney. So he represents us and gives us training and gives us insight on, what's happening, on the legal side of owning and managing rentals and working with tenants, but also on the contract side. So we look at Cullimore and their agreement, and just about every year, every few years, they modify, they update based on what they've learned from the many court cases that they've had, the many situations, and working with some of you or working with different landlords across the state. And so they give some updates to the lease and they give some recommendations. And this year there were 22 kind of substantial, or significant updates to the lease agreement. And so we'll go ahead and, I'm not going to bore you by going through all 22 items right here and now, but I'll put a link somewhere in the email or in the video to where you can see what those changes are. These will be starting to get incorporated into our Keyrenter lease as well, so that we can, again, just have the latest and greatest cutting edge lease that helps protect us and our property owners and allows us to operate rental property in the best possible way we can. Okay, so I hope this is helpful for you guys, and everyone have an awesome day and an awesome week, and take care. See ya.